Hi, I'm Jerry Sparks, president of AG Financial Insurance Solutions, and we have with us again Rich Hammar, renowned attorney on church law and taxes. And Rich, boy, we have a subject today that I think is going to affect everybody, and that, we've got to love technology, but with technology, anytime you have an advance in any technology, you have legal issues that follow. So, we've got cell phones now that we didn't have 20, 30 years ago. Texting, who ever heard of texting? Internet, email, social media. Almost put the postmaster out of business. But with all these issues come legal issues. Mm-hmm. Let's discuss some of the legal issues that we have with with this advancement in technology.
Sure, Jerry. There are a number of legal issues associated with social media, and we're going to look at 5 or 6, maybe 7 of those today. And let's start right out with what I call discovery, which is a word that is used for the gathering of evidence in lawsuits. So once there's a lawsuit filed, there's a period of sometimes months or years where both sides try to get information from the other side through depositions, through subpoenas, through requests for production of documents, et cetera. And what's happening today, and I've seen this over the last few years, it's common in litigation for a church to be, if a church is being sued, that the church is asked to produce social media records. Let me give you an example of a recent case I was involved in. Here's what one of the requests for production of documents said. Any relevant documents maintained on any computer in the church's possession or control, including those documents and emails stored in any online email account, such as Yahoo or AOL. Any computers or digital storage devices used during the plaintiff's employment with defendant, emails in any way pertaining to the facts of this lawsuit, and Facebook and other social media data. Now, what are they looking for this information for? Because they're hoping in that pile of responses to find some, what attorneys call a statement against interest or an admission against interest, which is an exception to the hearsay rule. Because usually out-of-court statements cannot be introduced in court to prove the truth of what was stated, because that's hearsay. But there's 30 to 40 exceptions in most states to the hearsay rule where there's a presumption of veracity given the circumstances, and one of them is admissions against interest. People normally don't make statements against their own interest, and so those statements, if you can find them in that pile of emails and social media messages, they have a strong probability of being truthful, and so they're considered to be an exception. And so just think about, Jerry, the typical church where if you would comb through all of those social media records, how likely would it be that you're going to find something in there that would meet that definition of an admission against interest? A pastor or staff member making some statement, maybe a board member, against the church's interest.
It's absolutely true, and that's the reason why you have to really watch what you put in your emails or text or anything else, because you never know, all they got to do is find that one little time that, you may have been joking, and it comes out.
It comes out. And so, for example, you have a senior pastor that's out driving to the hospital, and a staff member at church receives a lawsuit in a case of child molestation. And so you text message or call the pastor, and the pastor text messages back or emails back, yeah, I always had a bad feeling about that guy, that perpetrator. Why didn't we screen that person? Boy, we're going to be in big trouble now. This kind of thing is common, and yet that's a classic example of an admission against interest that's an exception to the hearsay rule in most jurisdictions, and that is going to be admissible in court in all likelihood. So you're admitting your own liability. So I think in staff meetings, periodically, there should be some mention of this and to urge staff to be very careful about what they communicate in an email, in a text message, so that that can't come back to hurt you in the future. And so just have a filter that before you hit that send button, you should be thinking to yourself, is there anything that I've just written that could be used against the interest of myself, my church, a staff member? I better rethink this.
Taking that one step further, you can look at innocent exchanges that youth pastors may actually have also with some of their students. You're looking very nice today. Just little things like that happen, and youth pastors get in big trouble.
They get in big trouble. And it's not limited to youth pastors, but, and we've talked about this before, Jerry, I've read a number of cases where youth pastors have been convicted of a felony. Usually it's contributing to the delinquency of a minor, can be other crimes as well. For what? For sexting, involved in a sexually explicit text message or email communication with typically a member of the youth group. And that can result in felony criminal liability. I read 3 cases just within a day or two a few years ago where that's exactly what happened. It was a youth pastor, unrelated cases, different states, but the common denominator was each of those youth pastors was sentenced to 5 years in a state penitentiary. I mean, think of that. They're sitting there in church, sending what they think are innocuous emails in this case, they were male youth pastors and female adolescents in the youth group. They were sexually explicit. Each of these guys is now languishing in a prison cell for 5 years. Ministry destroyed. They'll be on a sex offender registry for the next 25 years. And they were married. They had little kids. Think of the shame, the embarrassment. It is horrendous for what they thought was simple, innocuous entertainment. And again, it's not limited to youth pastors. I've seen this with senior pastors as well, communicating sexually explicit messages with one recent case involved an adolescent in the youth group, and that guy was sentenced to 186 years in prison. Now, there were other crimes for which he was guilty, but that was one of the significant ones. So I think there's got to be training of youth pastors, people that the church sets aside to work with youth in the church, to lay down the law when it comes to social media communication. I recommend they be prohibited from communicating via social media with members of the youth group. Yes, I know there may be reasons why it's desirable for them to have that communication, but yes, there are risks involved too that to me are unacceptable. I teach a 5th grade Sunday school class. I have a mentoring class for junior high students as well. The idea of me sending a text message to any of these kids, hey, how you doing today? You look really nice. Give me a break. I would never do that. Yes, there may be reasons why it might be helpful for me to be able to access these kids by email, but I never do it. The risks are too great.
The thing of it is you can do a group email to all of them at one time, but do not specifically do things individually, and you get the same thing. If there's a change in your class, it's not going to be meeting today. You can do it to everybody. I suggest also having the parents' emails on there so we don't have that issue. So with current laws, there's been a lot, like I said, 20 years ago, there were no laws in regards to cell phone use. Now, several states have laws on how to use a cell phone and what you can be held liable for. Why don't you go through some of those?
Yes, this is the most recent data. This is dynamic information. It changes frequently, so it may be out of date by the time you look at this. But as of the date of this presentation today, handheld cell phone use while operating a vehicle is prohibited by 11 states and the District of Columbia, which prohibit all drivers from using handheld cell phones while driving. 11 states plus D.C. All those laws are what are called primary enforcement, meaning you can be arrested for only that crime. It doesn't have to be secondary enforcement, secondary to another traffic offense for which you're being stopped. There is no state that bans all cell phone use by all drivers. But 37 states and D.C. ban cell phone use by novice drivers, people under the age of 50, for example.
Yeah.
We're talking about, the age differs, but you're looking at adolescents and teenagers typically in these states. How about text messaging? 41 states plus D.C. ban text messaging for all drivers, and that number's growing. In fact, there are calls in Congress to enact federal legislation that'll be uniform in all 50 states, certainly with regard to text messaging and maybe the use of cell phones. We'll see how that plays out. Then many cities have passed their own cell phone laws, but in many states they have what are called preemption statutes that prohibit cities from enacting laws This is really a matter of state interest. So as a result, most communities don't have their own cell phone laws. Some do, but most of these laws are going to be at the state level.
You know, one of the things that I would suggest to all of the churches that are listening is having a cell phone and handheld device use paragraph, probably they can put it in their employee handbook, but have a policy for cell phone use. And actually, I'll just kind of go through this a little bit, but the driver should not use a cell phone or any electronic handheld device while operating a corporate or rental vehicle. If cell phone or electronic handheld device use is necessary, the driver should pull off the road. If the driver is unable to pull off the road while using a cell phone or electronic handheld device, the following uses are allowed unless prohibited by federal law. Cell phone hands-free use, and a lot of cars now have the technology where you can just do this right from the steering wheel and it comes through your car phone. Cell phone use is a GPS. As long as you're not using that hands-free, as long as it's hands-free, you put it up on the dash and it's speaking to you, that's fine. But if you're using your cell phone for your GPS and you're listening to it and you're watching it, you're going to be in trouble. And GPS or other electronic voices, if voice prompted, and again, hands-free. The following cell phone or electronic handheld devices use is not allowed under any circumstances. Handheld cell phone use, texting. Cell phone use is a GPS that is not hands-free. Internet on cell phone. GPS or other electronic handheld device use. I know that we've actually changed some of ours to, people keep doing things, and again, technology gets better and better where nobody's really using GPS devices or using their cell phones anymore because of the maps that they have on there. And we've actually had to change our policies because of technology continuing to get improved. Then there's the enforcement.
And this is all by drivers.
This is all by drivers.
So a passenger is certainly free to use a cell phone.
Yeah, so if you're driving and you have a passenger, your passenger can give you the directions and they can do all the, they can handle all of this while you're driving, but don't be the driver and be doing this. So then there's the enforcement of enforcing this policy, and we'll get to talk a little bit about that. But with all this new technology, how does this affect the church itself?
Well, in terms of the church's liability, Jerry, let me just mention 4 ways that a church can face or be exposed to legal liability as a result of deaths and accidents caused by employees or volunteers even that are acting or driving a motor vehicle in the course of church business. And the first, of course, would be just ordinary negligence, which means carelessness. And in this context, what that would mean would be if a pastor or staff member or church volunteer is texting and causes an accident, kills people, injures people, the church could be sued on the basis of negligence for failing to have enacted a cell phone policy. So that's one way this can happen. Number 2 is respondeat superior, which is a legal term meaning the superior or the employer responds. And what that means is employers are generally liable in this country for the negligent acts of their employees committed within the course of their employment duties. So if you have a staff member that's driving a vehicle on church business, and even though it's a personal vehicle, it doesn't matter, and is negligent, text messaging, emailing, whatever, is distracted, causes an accident, injures or kills people, the church is going to be liable for that because it is liable as the employer for the negligence of its employees committed within the course of their employment. And then a third basis of liability is what is called negligence per se. And what that means is you were negligent in violating a statute. And this gets us back to what we said a moment ago, all these laws dealing with cell phone use. If you injure or kill somebody while you are in the process of violating an applicable statute or ordinance, that's called negligence per se. Negligence is presumed. It doesn't have to be proven. The only thing that has to be proven in these cases is the amount of damages. So that makes it even more important for church staff to be sure they're complying with these ever-changing cell phone laws. Because if you are violating that law and at the time that you cause an accident resulting in injuries or deaths, negligence is going to be absolutely established by the mere fact you are violating the applicable law. All that matters now is how much you're going to have to pay for it. And that's the third. And then the fourth type of liability is really applies to board members as well, and that's what is called gross negligence. Anytime a church or church staff member or volunteer is engaged in not just ordinary negligence, but gross negligence, then there are two important implications of that. Number one, the church itself can be subject to punitive damages, which are damages that are not covered by any insurance policy and are designed to punish you for especially reprehensible, reckless behavior. And furthermore, members of the church board, who generally are given limited immunity from liability for their ordinary negligence, they're not immunized from liability for their gross negligence. Sometimes it's called willful or wanton misconduct. And so it makes it extremely important, I think, Jerry, for church boards and for church leaders in general to be familiar with the concept of gross negligence, which basically means it borders on reckless behavior. It's more than carelessness, which is ordinary negligence. It moves toward recklessness. And you know, when you think about how can a church board member be guilty of that type of behavior, because it's so important to understand this, because if you violate that, if you are guilty of gross negligence, then that exposes the members of that board to personal financial liability. Let me mention 4 ways that this can happen. Number one, your church board says, we're not going to adopt a policy for screening youth workers to determine their suitability or fitness for working with children in our church. That risk never could happen here. You talk about gross negligence, there's a good example right there. Or how about number 2, continuing to use church vans without restriction? Or how about number 3, which would be continuing to use non-compliant cribs in the church nursery in violation of the Consumer Product Safety Commission regulation that took effect last December. And number 4 is, I believe, Jerry, it could be argued that a failure to adopt a cell phone policy that prohibits the use of cell phones under many of the conditions you've outlined, that can result in adverse employment actions. And so if a church fails to have that policy and its staff are under no limitation, according to the church, then that could be viewed as gross negligence if a church staff member or volunteer is involved in an accident because of the failure of the policy. And so it gets back to the issue here of, and you mentioned this before, of enforceability of your policy. And I think one of the best ways, people ask me that all the time, so you have a policy that's very effective with many of the limitations you've mentioned, Jerry, but how can you be sure that staff members are following it? And that's always a question anytime you have a policy. That doesn't mean not to have one. It means there's got to be continual education in staff meetings that here's our cell phone policy. You are responsible for following this, because if you don't, you're exposing the board and the church to potential astronomical liability. And to enforce this, I recommend a progressive discipline policy, that for a first known offense, there's a reprimand. For a second known violation of the policy, there would be maybe a week off without pay. The third infraction, termination. I believe that strongly in what we're saying here today. And really, apart from progressive discipline, how are you going to be sure, have any confidence that the policy is being followed?
If the church doesn't follow through with the enforcement that they put in their policy, then actually, again, you get into, it is complete gross negligence and negligence per se, because actually you're not following the rules that you set forth.
It would be gross negligence, but in all likelihood, but it wouldn't be negligence per se, because that involves a statute. That involves a law that you're violating.
But it is gross negligence because they are not following their own recommendations.
That argument could be made, yes.
You know, there was a recent New Jersey case that both you and I read about that actually, in my opinion, changes the way things happen that everybody needs to think about. And this just happened. Would you share a little bit about this New Jersey case?
Yes, Jerry. Just to stay current on all developments pertaining to religious organizations and clergy. I read about 12,000 cases every year. That's about 1,000 a month. It turns out that's about 33 cases a day, 7 days a week. And you say, well, that doesn't sound like a lot. Well, you know, it's that is a tremendous amount of reading. Some of these cases are hundreds of pages long. Some of them are just a page or two, but the average is probably 10 or 20 pages. But occasionally, I will read a case that just takes my breath away. I mean, I'm just startled. I'm stunned. I say, whoa. And fortunately, I'm a fast reader. I have zero comprehension.
It wasn't a short case to read either.
It wasn't a short case. But what happened in this case was this guy, this teenage young man, was driving a pickup truck and in New Jersey, and he's texting his girlfriend. And he goes over the brow of a hill, and he crosses the center line. And coming up the other side is a motorcycle with a husband and wife on it. And the pickup truck slams right into that. Oh, it was terrible. They both the husband and wife lost at least one leg apiece. And so they ended up suing the young man. And as that case was proceeding, their attorney also named the girlfriend, as a defendant in the case, who was texting with her boyfriend at the time of the accident. And this was unbelievable, but for the first time in the history of this country, a court ruled that the sender of a text message can be liable for injuries caused by the distracted driving of the recipient of that email if two things are present. Number one, the sender knows that the recipient is operating a motor vehicle at the time, and secondly, has reason to believe that the recipient will respond with a text message while driving the vehicle. And so the question becomes, how do you prove that somebody knew that the recipient of the text message was driving, or how do you know or have reasonable belief that the person is going to respond to you? I mean, sometimes you send a text message and the person doesn't respond for a couple hours. But how do you know the person is likely to respond to you while continuing to drive that vehicle? And so the court gave a couple of, well, their response to that was really based on prior texting experience. And I think also, given the fact that the person immediately responded to your text and initiated a text conversation, you know the person's texting while driving, so long as you know the person's operating the motor vehicle. How do you know that? Sometimes by scheduling. You know, the senior pastor is going to an appointment at 1 o'clock. It's 12:15. It takes 30 minutes to get to that appointment. You can infer by scheduling if the person's operating a motor vehicle. Many times they tell you they are in the text message. Or maybe it's a cell phone call, and they will say, yeah, I'm still driving. You can hear the traffic noise. And so maybe poor or variable reception is another way you know the person's operating a motor vehicle. But the court referred to prior experience. Is there a history of this kind of communication going on? So if you have that knowledge, then the New Jersey Supreme Court or Appellate Court said there can be liability for the sender. And of course, vicariously under that respondeat superior doctrine, that can also apply if the person is sending in the course of employment responsibilities. So, you know, it could be somebody in the church office texting the pastor or a youth pastor or another staff member you know is driving a vehicle, according to this case. If you have reason to believe they're going to respond to that text, you see it with your own eyes, they're responding. And that causes the recipient to be distracted, that exchange, and cause an accident, injuring or killing other people. That sender, according to this case, can be liable for those injuries, and vicariously the church can as well. So I think that's a very important development. The same logic there, Jerry, is going to apply just to cell phone calls, and it's going to apply to emails as well as text messaging.
You know, it's amazing because you never, you hear about laws all the time. And again, this is just a groundbreaking case. Mm-hmm. But how many times do we call people and, we know we're calling their mobile phone or we're emailing them and they're on the road and we're hoping that they're not going to be checking it out.
Let me give you a personal example. It just happened 2 days ago. An attorney called me to discuss a case, and you know how it is sometimes where the reception is so bad. Well, you figure the guy's on a cell phone, which he was, but it just was getting worse and worse. So I inferred that the person was traveling, and I said, "Are you driving a vehicle, not just in a vehicle?" He said, "Yes," and he said, "Let me move over to maybe a better area for reception." I cut off the call right then. I said, "Call me when you're done driving," because I was thinking of this New Jersey case. You know, if I'm willfully engaging in communication with somebody, causing him to be distracted because I know he's driving, and he causes an accident, I could be potentially liable for that if the courts in my state follow this New Jersey case. And let it be said, this is the first case in the history of the country to recognize this liability. But I see this happen all the time. This is how expanding liability happens. You start with one case, which is the icebreaker, and then all the little ships follow. And so I would expect we're going to see a lot of litigation on this issue going forward.
I agree with you. It's this. If there was one thing that, you know, when we discussed having this subject, when I read that case, I said, boy, we need to talk about this, because how many of us either call or text or, you know, and you got to think, you know, you almost have to ask, is this person driving?
Yes, that's right.
If you're driving, if you pull off the road, I'll talk to you. If not, call me when you get off the road.
That's right.
So great policy.
That's what I did 2 days ago.
Yeah.
I'm following my own advice.
I'm going to go ahead and give you a question, if that's okay.
We have 4 more topics to cover, but we may have to.
There we go. And this one basically says, if I suspect a youth pastor giving inappropriate contact or texting with an individual, can I look at their cell phone?
That was one of the topics we were going to cover.
Yeah.
And there it is, served to us on a silver platter. And the answer to that question delves into the concept of workplace privacy and employee privacy. And the answer was not clear up until 2010. But in 2010, the United States Supreme Court rendered a ruling where it addressed this whole concept of workplace privacy and the right of employers to inspect, in that case, a pager that was provided by the employer. Did the employer have a right to inspect its own pagers? And so the court said this, and the ruling is expansive enough to apply to any electronic technology, which would include cell phones, computers, et cetera. When it comes to an employer-provided device, such as a cell phone, the youth pastor has a church-issued cell phone. The employer, the court said the employee does have a legitimate expectation of privacy in what's on that device. But that expectation of privacy can be overcome by the employer, and its search will be legitimate and valid if 2 things happen. Number 1, the church has, or the employer has, a legitimate work-related purpose in looking at that phone. Not just a fishing expedition. Well, every month we're going to inspect our staff's cell phones just to see if there's any problems. No. But if the church has a legitimate, probable cause to believe that there's inappropriate usage of that cell phone, there has to be some extrinsic evidence giving rise to that concern. Is there a legitimate work-related purpose? Then that's the first prong. And the second prong is that the employer's search was not excessive given its objective. So that's the 2-step test the Supreme Court of the United States articulated in 2010, and that's the analysis that will apply in that case.
So let's say we have a parent complain and go to the senior pastor, but let's say it's not a church cell phone, but it's the youth pastor's own individual cell phone. How does that affect it?
Well, that does affect it because there the privacy expectations are multiplied, and the employer's authority, prerogative to inspect the device is considerably reduced because it doesn't own it. It didn't provide it. This is the employee's own personal device, whether it's a computer or cell phone. And by the way, the Supreme Court did not address that issue. So we don't have any national precedent here to go on, other than to say there's no question that the employee's expectation of privacy or privacy interests is going to be greatly expanded if it's his or her own device. So I think employers have to be much more cautious. You can always ask.
Absolutely, and that's exactly what I was thinking. And you're going to at least ask that employee, say, I think I would address it with the employee and basically say, you know, this is some information has came to us, a complaint from a parent, and this is what was inferred. Can we look at your cell phone to see if this happened?
And of course, you can always ask the parent.
Yeah.
And say, they're the ones making the complaint. Give us some evidence. We'll take a look at it.
Yeah, you could get the child's, you know, if it was a parent that complained about the child, you can get a copy of her cell phone because a lot of times it's there also.
Yeah, but that's an excellent question.
So, well, I know we're out of time again. We did have a couple more things we were going to try to cover, but as always, we got a lot of information in a short time period. We appreciate you watching Risk Management Live, and we'll see you next month. Thanks, Rich.